Hey, Jordy.
Oh yeah.
I'm great. How you doing?
Good, good. Well, thanks to everybody who joined and is joining as we speak. Welcome. Glad to have you aboard. We're going to do a topic that is, very important for the client, but it's one of those that is really where clients get value from us, where we can add value is our advice on this fundamental question. So, Ian, any thoughts off the top before we dive into this?
Yeah, no, I agree with you. The return on investment sort of approach. What value can we give? I'm always surprised how generally uninformed clients are and the public are about both the selection and how much you get paid for this job. So I think it's a real added value to us as lawyers and our service to the client.
Well, great. So let's kick off. Here's our agenda. We're going to talk both about factors that might go into influencing a decision on executor choices and trustee choices. Two different roles there, and maybe different considerations. How many we should be picking, how to advise clients about that, and then ultimately compensation. Um, so let's just talk first. And when I talk to clients about these positions, I often leave it till the end because, in some ways, the plan itself will lead us to the advice on who to pick here, because the executor's role is distinct from the trustee's role. An executor's role, right? And this is useful for clients to understand. I often get that question, what's the difference between an executor and a trustee and an estate trustee and a this and a that, right? Um, and so I try to at least give them the outline of what the role is. First of all, the executor starts immediately. The role starts immediately, and they're going to deal with funeral and burial, and they have the ultimate decision on that. They're going to collect the assets, liquidate, pay debts, file taxes, all those things. And then their job really is to distribute in accordance with the terms of the will. If there are trusts in the will, that is a separate role in essence. Their job is really to transfer it to the trustee of any trusts. So they're distinct roles, and the real key here is the executor's role is limited in time. Even if you've got an ongoing, can everybody just turn off their cameras if you don't mind? Just affects the speed of the presentation and the connection. Um, so, distributing, regardless of the complexity of the will, as far as the dispositive provisions go, really, it's a limited time frame, right? 1 to 3 years, and the estate is generally wound up. Now, of course, there are exceptions, but that's the end of the role of executor. Um, that's distinct from the role of a trustee. Because let's take the situation where you have a very straightforward will. It says everything goes to the two kids, absolutely, and both kids are alive. Then there's no trustee role. The gifts are absolute as we describe them. There are no trusts associated with them. There are no trusts associated with any of the gifts. We don't have a trustee role in those. On the other hand, if, for example, money is being held for a person until a certain age, an age trust for kids or grandchildren or something like that, or they're managing assets like real estate for a period of time, and there's a trust involved there, then you have a trustee role. Ian, anything to add here before we get into the role of that trustee?
No, I think this is pretty straightforward, but important delineation to make.
Yeah. So this one, the trustee role, and of course you can always separate and have different people as an executor and different people as a trustee of any particular trust. You could have a different trustee for every trust. Um, so the trustee's role is they get the money or asset from the executor, in essence. Now they've got to invest it or manage that. They have the big decision in often um, as far as discretionary distributions. They can decide how much and when a beneficiary might get money from the trust up till the end of the trust. They have the obligation, like executors do, to keep accounts and report to the beneficiaries. They have income tax compliance roles. They have to ultimately distribute the assets on the death of, typically on the end, at the end of the trust, whether it's death or an age or whatever. And it's ongoing and continues until that trust is finished. So those are the key elements of a trustee's role. And therefore, that role, depending on the terms of a trust or the plan, etc., other considerations are going to be relevant. And the choice of trustee in that situation may be different than if it was had the trust had different conditions.
Yeah, and you want to look ahead to that role kicking in if you're in a situation where you're going to have to convert yourself into the trustee role as opposed to executor's role and manage things to anticipate. All right, well, look, if I drop all of this money into the trust, for example, if there's a designated trust that you're going to be administering, a testamentary trust, do you need to hold back for the estate? Do you need to make sure that you've got access to funds to pay CRA? If it's a completely different set of circumstances with that testamentary trust. So you want to look ahead before as you are transitioning into the role. It's not just dropping the money in. That's of course the start date, but anticipating some of the problems that might get created. If you drop all the money into the testamentary trust, you may be in a situation where it's not as easy to pull it out for ongoing expenses and things like that. So you want to watch for that.
Yeah, and like with any distribution, you don't want to, if you're the executor, you don't want to give all the money away and then have to come back to the beneficiaries or the trustee of a trust. So let's talk about the key attributes. And this is a slide, quite frankly, that when clients ask me, well, how do I pick an executor or a trustee? This is a slide that I like to pull up and go through these issues with the client. So let's just start at the beginning. A key attribute, and this is going to be for executors or trustees in many cases, obviously trust, right? You need to have faith in the person you're picking. You need to believe that they're an honest person and trustworthy. And so that's probably, number one, and it's by definition, I guess, as well. People ask as well, what skills are required? And if I were to suggest, what skills are required, people say, oh, they're great with investments, great with investments. How important, Ian, is that in your view? And what skills are crucial?
My I always tell my clients in a situation like that, and is this: I say, pick the choice of executor as someone who has these kinds of skills, i.e., an ability to delegate, an ability to know what he or she doesn't know. And if you've got that ability, you can simply surround yourself with the types of skills that you need. I mean, I wouldn't want to guide myself and my own portfolio, my little RSP I might have. I rely on an advisor. What do I know about the market? I'd be buying something that makes no sense. So it's people who, I often will say, know what they don't know, but have some empathy, and also can park their ego to look to others to assist.
I think that's really so important. I mean, often people say, "Oh, I'm going to appoint my brother-in-law. He's great with investments." Often that's actually they're not necessarily objective, and they might manage it the way they manage their own investments, right? That's different than managing a trust for minors or other beneficiaries. And so sometimes that's not, I wouldn't rank that at the highest level. And I agree completely with you. I think for me, somebody who's an organized person, yeah. I mean, you don't want somebody who's just, they can't get anything straight. They're not good with documents. Things fall through the cracks. That's really, that to me is the biggest, and the ability to get to recognize they need help and delegate, so crucial. Um, Other things, the ability to communicate with the beneficiaries and keep an open line and be willing to do that. communicate, and park the ego is so important.
Yeah, and I think the willingness, and also again coming back to who are you going to get to assist you in ensuring the proper communications are going out. You just send a list of assets, and someone might say, "Hey, look, I thought Mom sold her house 5 years ago. Why is it only at that amount? Wasn't it invested or something?" Like you're going to be in a situation where the nature of the communication needs to be fulsome, and sometimes you think you're doing a good job, but you're not being guided by someone who says, "Look, you know what, I've seen this sort of thing before. If you just send out a bunch of numbers, it just pisses them off. Let's do this, let's put a little narrative behind it and do that kind of stuff."
Yeah. And tying into all of this is the personality of that potential person. I mean, what's their personality? Do they work well with others? Do they not? Are they, arrogant? Are they, easy? They like to involve help or collaborative or those kinds of person. Like depending on the circumstances, one type of personality might work better than another. And that's really some, clients won't understand that. In most cases, they've never been through this. They've never been an executor. They don't know what's involved. And so, sharing some experience about that, is so important. Um,
I agree. And then, the next two really, I think are so important in so many respects. Cultural considerations as well, sharing the shared values. Do you have someone who's going to step into the role, who's not going to be able to understand sort of maybe the unique circumstances of the family, that sort of thing. But age and health is one that I bump into all the time because they think they've thoughtfully considered us, and their choice of executors like 83 years old. Now
yeah.
I'm getting to the point where I can no longer qualify, but the point is that you want to be sensitive to the reality that your choice has to reflect some longevity.
Yeah. And the shared value is, in my view, more important on the trustee situation appointment than on the executor. I mean, the executor, the way I kind of describe it, it's more administrative. I mean, they sell the property, they get the money, they file the taxes, they pay them money. But determining about where there's discretion, especially on encroachments and how you're going to support a child through their younger years or early adulthood, those values are really, that's when shared values are so important. um, and age and health, that can go right to the top of the list. Again, for an executor it's one thing. um, okay, they need to be around and willing and able, I guess able here, for, 1 to 3 years after death, say 3 years after death. But if you've got a lifetime trust for somebody, that and they're 40 years old and it's going to be held in trust for the rest of their life, and they got 60 years, max, kind of idea here, who's going to, then age is so much more relevant, right? Um, so that's why sometimes I like to know what's in the plan before we start picking these people, right? That's going to definitely be relevant. Um, Willingness. What do you tell clients about willingness? Because people always say to me, "Oh, I'm going to go check with I'm going to name John, and I better go check with him and get his okay." Um, what are your thinking? What's your thinking on that?
Well, again, it so ties, as you say, whether you're going to have an administration that's an executor only or a trustee and executor, because I'm a big fan of telling the executor that they have the job. One of the problems you do find, and I see it all the time, is that someone has appointed an executor, and the first thing they do is on the date of death is file their renunciation, and you've put this thoughtful consideration in, but you haven't set it up. So I'm a big fan of going through it with the client, making sure they understand what they're to expect. And sometimes I'll assist by giving a sort of a summary of what the executor is going to be expected to do in their role, and then and ask them, if they want, they can hand it to the proposed executor so that they know a little bit about what they're getting themselves into.
Michaela, did you have anything that you wanted to add here? Sorry, or let me know. Okay. I just saw you went on mute. One thing, just to be clear with everybody, a beneficiary can be an executor. It's quite common. So that just to clarify that, as there was a question in chat, just yeah, of course, a beneficiary can definitely be an executor and or a trustee.
And so
Um,
can a lawyer. I mean, just as an
yeah,
interesting aside, there was some time where there was a consideration of the new rules of practice required us to always get independent legal advice for the client if you were going to get a gift. And that's fair. That makes sense under a will of one of your clients. But the appointment of being a lawyer is not a gift, and it does not require independent advice. And that has been verified by the Law Society time and time again. So that's not something you need to go out and send the client away if they've chosen you as an executor and you're their lawyer.
yeah, thanks for, yeah, absolutely. The willingness thing, just to stay on that for 1 second, what I always say to a client is they might tell you today oh yeah, they'd be happy to act. I said, that's fine. They may change their mind, and they can change their mind at any point and not tell you, so that's why we need alternates, and we'll talk about that in a second. Impartiality, potential for conflicts. You see that sometimes where, their partners, I want to name my partner who's in the business as an executor. Well, there's a conflict. They might be on the other side of the shareholder, of a shareholder dispute or partnership dispute about valuation or those kinds of things. So keeping in mind about the fact that there are potential conflicts between the executor and their duties is important.
Yeah, but I do think it's something, it's one of those things you've got to dance very carefully because, of course, almost every executor is going to have a conflict at some level. And people
Right.
get all excited. They're like, oh, they can't be the executor. They're going to have a conflict. Well, no, that's not the law. And the courts actually presume a conflict. And it's just you're governed by fiduciary obligations and fiduciary duties. So that conflict gets diminished as a consequence of the rules of the common law rules of fiduciary duties. But so I often on a client, I'll just sort of eliminated someone. I'll go, well, wait a minute, maybe that's not such a terrible thing. And well, there's a conflict. Well, no, actually, we'll get around that.
Yeah. I mean, it is important because the court will defer to you, even if you put somebody in a conflict and somebody raises it after the fact, oh, he's in a conflict. Well, the fact that the testator chose somebody who was in a conflict, the court's like, yeah, they're entitled to do that, as you've said. So, but raising those issues with the client to think through them, that's really value too. That where is there going to be, where are they going to have issues, and maybe they're right or maybe they're not right. Residence and citizenship. First thing I'd point out here is there is no prohibition against appointing a foreign resident or a foreign citizen as an executor or as a trustee of a trust. There are reasons why you wouldn't want to do it, but there's no prohibition against it. So in a perfect world, you'd appoint a resident of Ontario for an Ontario state to be the executor and the trustee. Um, but there is no prohibition in naming someone else. There are tax implications, potentially if it's a trust, that the trustee is a foreign resident, that can cause the trust to be foreign. And there are administrative issues and logistical issues where you've got foreign people. There are rules about giving investment trading instructions by a person who's not physically present in Canada. There are bonding issues, which we've talked about before for foreign residents as executors, but nothing is a prohibition. Ian, what do you do? This is probably let's just talk about that for a second because that's probably one of the most common questions we get is I've got a US kid and what should I do?
Yeah, and you've just listed for almost all of the good reasons why you wouldn't want to bring a non-resident into an administration of a trust. And so, from a practical standpoint, my answer is stay away. There are 5 or 6 good reasons why you probably shouldn't pick anyone outside of Ontario, and we'll have to look at options. And that's when you start to consider things like trust companies and things like that, because it is so onerous. And the truth is, as you say, I mean, a little bit of tax, I know, there's the ability to turn this into a U.S. trust if it's a testamentary trust situation. So all of those good reasons. You're absolutely right. There is no prohibition. It's just practically speaking a bad idea.
Right. Couple more obviously somebody with some experience in who has done this before, that's often more helpful. Although if they've done it before, they probably never want to do it again.
Yeah.
So that's it's a double-edged sword there.
Yeah, but you're also
Geographic,
going to find that's where lawyers are well suited for. To be
yeah,
honest, like there are a lot of good lawyers on the street who can do this job well and efficiently.
yeah, for sure. We talked about some of the issues about being geographically not present, cleaning out the house and things like that. Um, the last one, relationship impact, which I think is uh, um, uh, underestimated as far as a concern. Um, oh, I want my brother to be the trustee for my kids. Um, Great, he might fit all of these other considerations. Now, though, it's not uncle niece, it's trustee beneficiary. It can really change the dynamic between those two people. And one rule I always stick by, subject to the client uh, acting against my advice, don't put one kid in charge of another kid's money, right? They may be the perfect person in every regard, except that they happen to be the sibling, and saying, and I just say to my client, so would you want to ask your sister if you can have some money to go down to Florida? How'd you like to do that? Oh, I wouldn't like to do that. Yeah, exactly. It's a recipe for disaster. Um,
Yeah, it's so true. And the relationship impact is, as you say, it's underestimated. And one of the other elements that I'm a big fan of walking through with the clients is in terms of the relationship is that doing exactly that kind of teasing it out.
mhm.
And when we've see a red flag, walk through some illustrations like you've done to just give the client almost certainty that they're probably going down the wrong path.
Yeah, and a bit, usually I am able to talk them out of it, but occasionally you can't, and well, okay. So at least I warned you. But those are the key attributes. For sure. Um, some other, and we've talked a little bit about it. If we're going to appoint a an executor who the beneficiary hates, or more than one executor, and they don't get along, that's obviously a key issue.
Yeah, and one that really has to be thought through when you're in a blended family situation. Boy, if you sit there and you point your sister to be your executor, and you've got a remaining spouse who's going to be governed and things like that from a first marriage and all that, like you just second marriage. I mean, you just have to be so careful in a blended family choice.
Yeah. We talked about the length of the trust, right? That's going to be key. The complexity of the administration, types of assets that are going to be managed. Are they going to be, a private company that's going to, an operating company that's going to be having to be managed? Are we talking about royalties and, and copyright and, are we talking about unique assets? Those things are all relevant to the selection of, for example, an executor. Um,
Especially closely held family corporations.
yeah. Uh, and replacements. I just want to talk about that. I mean, whenever a client says, "Okay, I want A to be the executor," we want to talk about what happens if A is unwilling, unable to act, and are there alternates to them? And how many alternates do we need? Well, I mean, the will won't fail if there's no executor, and a trust won't fail if there's no trustee, right? So there'll always be somebody there to take over, but it might not be the person you want, and might cost a lot more money to find somebody and get them appointed and all those things. So thinking about alternates is very important.
Yeah, you know, when you have multiple trustees in a situation where you may have some complexities in the estate, and you have that, often I'll say to my clients, "Now, let's make sure that we keep it simple on the replacement side. Don't necessarily identify, well, if the lawyer can't be there, then it's this lawyer or that lawyer. Like, just try to make it simple and try to make it a situation where that we know that someone can come in without having maybe to go to get a court order that unnecessarily and things like that. So it's a drafting issue for sure.
Yeah, so maybe just this idea, just brief, we could talk about that, is the idea of, for trusts, there is the ability to allow someone else to appoint an executor, appoint a trustee. The Ree Nichols case, if you're looking for authority, is well established. You can have someone, you can delegate that power. And so it's a good idea if you use eState, we have a trustee replacement provision says if I get down and I have no trustees left, the last trustee can pick a replacement or their executor can, et cetera. And so building in that level, because we see this all the time, Ian, where, okay, this person that wants to resign as a trustee, now what? But you can also do it, and I commend Professor Oosterhoff's article on Well Partners website about the power to delegate the authority to pick out a replacement executor, even. So, a couple minutes left. Take us through, Ian. Should we pick one person or should I pick more than one person?
Well, you and I have two different views on this. I know from chatting about this in the past. When you have multiple children, it's always a difficult decision. Do you put all in? Do you put one in? And I think it obviously depends on the circumstances. I think you lean more towards put them all in, and I lean more towards just put one in, but have a good discussion about it and make sure that everyone else in the family understands it and that they understand that they've got to be completely transparent. But that's a big decision when you have to choose the choice of executors.
Yeah, I mean, nothing. We look at the will could be exactly the same. The kids could get exactly the same amount of money. Okay, one's the executor and one's not. And we know, Ian, and anybody who's been in this area for any time knows that's enough to cause terrible feelings between the two, or certainly by the person who's not appointed, and embolden the person who was empowered and change the dynamic and all of those things. So important to talk through really the idea of, do we want to name just one of them, or how are they going to react? And how would you react if your sister was the sole executor over mom's estate? Um, it's not an easy decision, and there's no right answer, right?
No, but as you say, the decision-making clauses are what's, I think, resolve it. In the sense of, do you get a majority clause in there? Do you have that kind of opportunity if you're going to have multiple trustees? That's a good way of going through it. And I'm a big fan of making sure that the majority clause clearly says that they have to have, you have to ask. You can't just invoke the majority clause. You have to demonstrate that you've asked asked around for the decision. And then if there is no consensus, then you can invoke the majority clause, as opposed to people often read those majority clauses as well. Look, two of the three of us can just do this. I like to have that little nudge that, what, before you break ranks, you better have asked.
I mean, the reality in our final point here, and we get this all the time, when you appoint more than one executor, they are joint executors. Okay. We don't have joint and several executors. We don't have that power. They're together. They have to make decisions together. You can delegate certain decision making or certain actions, but ultimately they're all responsible jointly for decisions. And so a majority rule clause doesn't change that. They still have to. They're still, required to discuss and act together. It's just that a decision can be made by a majority, right?
Absolutely.
Yeah. And maybe just touch on why, just in our last minute, why can't you have a joint and several appointment in a will?
Well, because you've got joint and several liability. So ultimately, no matter what, no matter how you establish your arrangements, the fiduciary is jointly and severally liable personally.
Right. And that people dealing with them are going to deal with both of them.
Yeah,
And so it's different than a power of attorney that we allow that kind of appointment. Um, and so um, so we've run out of time, but I want to thank you, Ian. We're going to continue the discussion. We'll go over a couple. I'll do a little bit on common circumstances and compensation in the community. So if you want to join us over there, we'll continue this for about 15 minutes. Thanks, Ian. Thanks to everyone who was here. One last point is on Tuesday, for any eState users, we've released a whole bunch of new features over the past few months, and I'm gonna lead a session next Tuesday at 12:30 to get everybody up to speed on what do these new features do. Should I use them? Shouldn't I use them? Do I like that? And so please join us. We'll get something out to everybody, but it'll be this Tuesday at 12:30 with me live on the web. So
thanks,
thanks
Jordy.
everybody. Thanks, Ian, and see everybody over at the community.